Welcome to Module 6, where we turn our attention to public policy, law, and regulation in artificial intelligence. Up to this point, many conversations about AI ethics can sound as though responsibility sits mainly with designers, data scientists, engineers, and organizations. Those actors matter a great deal, but artificial intelligence now operates in spaces where private technical choices quickly become public consequences. When an AI system helps screen job applicants, guide medical workflows, detect financial risk, support public benefits decisions, or influence security practices, it is no longer only a question of model performance or organizational efficiency. It becomes a question of how society sets boundaries around powerful technologies, how those boundaries are enforced, and how legal systems respond when automated systems affect real people. The phrase public policy is important here because policy is broader than a single law or regulation. Public policy includes the choices governments make about what should be encouraged, what should be restricted, what should be monitored, and what should be treated as unacceptable risk. In the context of artificial intelligence, policy has to deal with an unusual tension. AI systems can produce enormous social and economic value, yet they can also create harms that are difficult to detect until after deployment. A policy framework, therefore, cannot simply say that innovation is good or that regulation is bad, because both of those positions are too shallow for the realities of AI. The more careful question is how a society can encourage useful AI development while still protecting privacy, fairness, accountability, safety, and democratic oversight. That question is especially demanding because AI policy has to speak to many audiences at once, including technical teams, corporate leaders, regulators, courts, public agencies, and communities affected by automated decisions. Law enters the discussion because policy goals need mechanisms that can be interpreted, applied, challenged, and enforced. A law may define obligations for developers, deployers, vendors, public agencies, or employers, but those obligations have to be specific enough to matter and flexible enough to remain useful as technology changes. That is one of the central difficulties in AI regulation. Legal systems usually move through deliberate processes, while AI capabilities, business models, and deployment practices can shift quickly. As a result, lawmakers and regulators are often working with moving targets, trying to write rules that address present risks without becoming obsolete or unintentionally blocking beneficial forms of innovation. This is why AI law often develops through a combination of legislation, agency guidance, standards, enforcement actions, professional norms, and international coordination, rather than through one single document that answers every question. Regulation adds another layer because it concerns the practical work of oversight. It asks who must document an AI system, who must test it, who must explain it, who must monitor it after deployment, and who must respond when something goes wrong. In traditional areas of regulation, such as finance, transportation, medicine, and public administration, society has already recognized that some decisions are too consequential to be left entirely to private discretion. Artificial intelligence brings that same logic into a new setting, but with added complexity, because AI systems may learn from data, operate at scale, rely on opaque model architectures, or be embedded inside larger institutional processes. That means regulation cannot focus only on the algorithm in isolation. It must also examine the organizational, legal, and social context in which the system is built and used. Throughout this module, we will treat AI governance as a public problem, not merely a technical checklist. We will look at why governments, and international organizations are paying close attention to AI, why emerging regulatory frameworks emphasize accountability and transparency, and why autonomous decision making raises difficult questions about responsibility and liability. We will also consider why international enforcement is so challenging when AI systems are developed in one jurisdiction, trained on data from many others, and deployed across borders through cloud platforms and digital services. By framing artificial intelligence through public policy, law, and regulation, we are asking a foundational question that every responsible AI professional needs to take seriously. When intelligent systems begin to shape important decisions, what rules, institutions, and safeguards should guide their use? The goal is not to memorize every statute or policy proposal, because this landscape is still evolving. The goal is to develop the judgment needed to evaluate AI systems as part of a larger legal and social order. In this slide, we begin with the role of public policy in legal systems in regulating artificial intelligence technologies. That phrasing matters because AI regulation is not only about controlling technology after something goes wrong, it is also about shaping the conditions under which AI systems are designed, tested, deployed, monitored, and challenged. Artificial intelligence now appears in healthcare, finance, education, transportation, public administration, and national security, which means its effects are spread across domains where decisions carry serious consequences. In each area, AI can improve speed, consistency, and analytical capacity, but it can also intensify errors, hide unfair treatment, or make decisions harder to understand. Public policy becomes the bridge between technical capability and social responsibility because it asks what kinds of AI uses should be permitted, encouraged, limited, or subjected to safeguards. In healthcare, policy questions arise around patient safety, clinical judgment, privacy, and the evidence needed before a system is trusted in care setting. In finance, similar questions appear in credit scoring, fraud detection, lending, insurance, and risk assessment, where automated decisions can influence access to opportunity and economic security. In education, AI may support tutoring, grading, admissions, advising, or plagiarism detection, but each use raises concerns about transparency, bias, student rights, and human oversight. Transportation introduces another set of issues because autonomous or semi-autonomous systems interact with physical environments, infrastructure, passengers, pedestrians, and public safety expectations. Public administration and national security extend the stakes further because AI may be connected to benefits, law enforcement, border decisions, military planning, cyber defense, and other areas where state power affects individual rights and security. Legal systems guide AI development and deployment by turning broad policy values into duties, procedures, and remedies. A society may say that AI should be fair, transparent, safe, and privacy protective, but legal systems must translate those values into requirements that organizations can follow and that courts, agencies, or regulators can evaluate. This may include documentation rules, impact assessments, auditing obligations, data protection standards, procurement requirements, notice requirements, or liability rules when harm occurs. The challenge is that AI systems do not always fit neatly into older legal categories because they may combine software, data, statistical inference, human decision processes, vendor relationships, and platform infrastructure. For that reason, legal analysis in AI often asks not only whether a system is accurate, but also who had control, who had knowledge, who benefited, who was harmed, and what safeguards should have been in place. policymakers also have to balance competing priorities, and that balance is one of the defining themes of AI regulation. Innovation matters because AI can contribute to medical discovery, accessibility tools, safer infrastructure, improved services, and economic growth. At the same time, citizen protection matters because individuals should not have to absorb the risks of poorly designed or irresponsibly deployed systems without meaningful recourse. Privacy matters because AI systems often depend on large-scale data collection, and data about people can reveal patterns, vulnerabilities, and identities in ways that are not always obvious at collection. Fairness matters because AI can reproduce or amplify unequal treatment. When historical data, institutional practices, or design assumptions carry bias into automated systems. Economic competitiveness matters as well because governments know that overly weak regulation can invite harm, while overly rigid regulation can push research, investment, and talent elsewhere. This is why the AI legal landscape is being shaped by many actors rather than by one institution alone. Governments write laws and set national priorities. Regulators interpret and enforce rules within specific sectors. Courts resolve disputes and clarify liability. And international organizations help develop shared principles, standards, and coordination mechanisms. These actors do not always move at the same pace or emphasize the same risks, which is part of why AI regulation can look fragmented and unsettled. Still, as AI becomes more deeply embedded in consequential decisions, legal and policy systems are moving from abstract ethical principles toward concrete expectations for governance. For professionals working with AI, the practical lesson is that technical success is no longer enough. Responsible AI development requires awareness of the policy environment, the rights and interests of affected people, and the legal responsibilities that accompany deployment in high-impact settings. Now we move from law and policy into the specific question of emerging regulatory frameworks for artificial intelligence. A regulatory framework is more than a rule written in isolation. It is a structured approach for deciding which systems require oversight, what obligations apply to different actors, and how compliance will be evaluated. In AI, this matters because the technology does not create risk in only one way. Some systems create privacy risks because they depend on sensitive data. Others create fairness risks because they influence access to opportunities. And others create safety risks because their outputs affect environments or services. So when governments and organizations design AI policy, they are trying to build frameworks that recognize different levels of risk. One major feature of emerging AI regulation is that it often focuses on the full life cycle of development and deployment. The concern is not only what the model produced at the moment of use, but how the system was designed, what data shaped it, what assumptions were built into it, how it was tested, and what monitoring continues after release. This life cycle perspective matters because many AI failures do not begin at the final decision point. They may begin earlier, when training data excludes certain populations, when a performance metric rewards efficiency over fairness, when documentation is incomplete, or when a vendor sells a system into a setting for which it was never validated. A serious regulatory framework therefore asks organizations to show their work, not simply to claim that a system is accurate. Algorithmic accountability is one of the central ideas in these policy efforts. Accountability means that the use of AI should be traceable to responsible human and institutional actors. Even when the technical system is complex, it should be possible to identify who selected the model, who approved deployment, who monitors performance, who responds to complaints, and who has authority to suspend or modify the system when risks become clear. This matters because organizations sometimes speak about AI as if the technology itself made the decision, which can blur responsibility and leave affected individuals with no clear path of appeal. Emerging frameworks push against that problem by insisting that automated systems remain embedded within human governance structures. Transparency is closely connected to accountability, but it is not the same thing. A transparent AI system gives stakeholders meaningful information about how and why the system is being used, what data or criteria may influence its outputs, and what limitations should be understood before trusting the result. Transparency may involve public documentation, model cards, impact assessments, user notices, or explanations given to individuals affected by an automated decision. Still, it has to be handled carefully because releasing technical details does not automatically produce understanding. The goal is not to overwhelm people with mathematical complexity, but to provide information that supports oversight, contestability, and informed decision making. Safety and responsible deployment are also becoming central regulatory concerns because AI systems increasingly influence important decisions across society. A framework that addresses safeties asks whether the system has been tested under realistic conditions, whether foreseeable failures have been considered, whether human oversight is appropriate, and whether the system can be corrected when performance changes. Responsible deployment adds the ethical and organizational dimension. It asks whether the AI system should be used in that context at all, whether the benefits justify the risk, and whether affected communities have been considered. This is why many emerging approaches treat high-impact uses differently from routine uses. The stronger the possible effect on rights, safety, opportunity, or public trust, the stronger the expectation becomes for documentation, evaluation, monitoring, and accountability. The broader lesson is that AI regulation is moving from abstract principles toward operational governance. Governments and international organizations are no longer satisfied with statements that AI should be ethical, fair, or trustworthy in a general sense. They are asking what those commitments require in practice, who must carry them out, and what evidence should demonstrate that the requirements have been met. For AI professionals, this means compliance cannot be treated as an afterthought, added at the end of a project. It has to be built into design choices, testing procedures, deployment plans, and post-deployment review. Emerging regulatory frameworks are still evolving, but their direction is clear. As AI systems gain influence over consequential decisions, society is demanding mechanisms to make their development and use accountable, transparent, safe, and responsible. Autonomous decision-making systems bring us to one of the hardest legal questions in artificial intelligence. What happens when a system does more than merely assist a human and begins to influence, recommend, or make decisions independently? The word autonomous can sound as though the system is separate from human action, but that framing is usually too simple. Even advanced AI systems are designed, trained, purchased, configured, approved, and deployed by people and institutions. So, when we evaluate the legal implications of autonomous decision making, we are not asking whether the machine has responsibility in the human sense. We are asking how responsibility should be assigned among the human and organizational actors who created the conditions for the system to affect an outcome. This issue becomes important when autonomous systems influence decisions that shape people's lives or an organization's obligations. An automated system may recommend whether a loan should be approved, flag a patient for additional screening, prioritize candidates in hiring, detect suspicious financial activity, or support decisions in public administration. In some settings, the AI output may be advisory, meaning a human retains formal authority over the final decision. In other settings, the system may effectively determine the outcome because human reviewers defer to it, lack the time or expertise to challenge it, or treat its recommendation as more objective than it really is. That distinction matters legally because a system can be formally human supervised while functionally autonomous in practice. Responsibility is the first major legal implication because affected individuals need to know who can be held answerable when an AI system contributes to harm. If an autonomous system denies a benefit, misclassifies a person, produces an unsafe recommendation, or generates a decision based on flawed data, the legal system must examine where responsibility belongs. It may rest with the developer, the deploying organization, the vendor, the manager who approved the workflow, or the human decision maker who relied on the output. In many situations, responsibility may be distributed across several actors rather than located in one person. That distribution creates difficulty because each actor may claim that another party controlled the relevant part of the process. Liability takes that question one step further by asking who should bear legal consequences when damage occurs. Liability may arise through negligence, product liability, discrimination law, data protection law, consumer protection, contract obligations, professional standards, or sector-specific regulation. If an AI system produces harm because it was never properly tested in the population where it was deployed, a legal analysis may ask whether the deployer failed to exercise reasonable care. If the system was sold with misleading claims about reliability, attention may shift toward the vendor. If the harm involves biased outcomes in employment, housing, credit, education, or public services, the issue may involve anti-discrimination duties even when bias was not intentional. The legal problem is not simply that AI made an error. It is whether human institutions failed to prevent, detect, explain, or correct a foreseeable error. Accountability is closely related, but it has a broader governance meaning. A legally accountable AI system should not operate as a black box that leaves people unable to contest outcomes or identify responsible decision makers. Accountability requires records, documentation, explanations, and oversight mechanisms, appeal process, and post-deployment monitoring. It also requires organizations to define in advance who has authority to intervene when the system performs poorly or causes harm. Without those structures, autonomous decision-making can create an accountability gap where decisions have real effects, but no person or institution appears clearly responsible. A mature legal framework tries to close that gap by ensuring that system autonomy does not become an excuse for organizational irresponsibility. The central lesson is that autonomous decision-making does not remove humans from responsibility. It changes where responsibility must be examined. The more independent and influential an AI system becomes, the more carefully legal systems must ask who designed it, who deployed it, who supervised it, who benefited from it, and who had the power to prevent or remedy harm. These questions become more serious as AI enters sectors that shape health, liberty, financial access, employment, education, safety, and public trust. Accuracy may matter, but legal responsibility also depends on fairness, transparency, due process, reasonable care, documentation, and the ability to correct harmful outcomes. For professionals working with AI, this means legal awareness has to be present before deployment, not after a dispute arises. Enforcing AI regulations across international jurisdictions begins with the fact that AI systems rarely stay inside one national border. A model may be designed by a company in one country, trained on data gathered from users in many countries, hosted on cloud infrastructure, in another region and then deployed through a platform that reaches customers almost everywhere. That global structure makes regulation much harder than it would be if an AI system were built, operated, and used entirely within a single legal environment. A government may have clear authority over organizations operating inside its territory, but it may have less practical control over vendors, data pipelines, infrastructure providers, or downstream users located elsewhere. So when AI becomes global, enforcement becomes a question not only of what the law says, but also of whether regulators can actually reach the actors whose behavior they need to influence. Cross-border deployment creates legal and practical difficulty because different jurisdictions define rights, duties, and risks in different ways. One country may emphasize privacy and data protection, another may prioritize innovation and competitiveness, and another may focus on national security, public order, or industrial development. Even when governments agree that AI should be safe, fair, transparent, and accountable, they may disagree about what those words require in practice. A transparency obligation in one jurisdiction might demand detailed documentation and user notice, while another jurisdiction may rely more heavily on voluntary standards or sector-specific guidance. For an organization deploying AI globally, this can produce a complex compliance environment where the same system may face different obligations depending on where it is used, whose data it processes, and what kind of decision it supports. Enforcement becomes even more complicated when harm crosses borders. Suppose an AI system developed in one country affects consumers, workers, students, patients, or public service users in another. Regulators may need access to technical documentation, training data information, audit records, vendor contracts, logs, or internal risk assessments. But those materials may be held outside their jurisdiction or protected by trade secrecy, privacy rules, or national security claims. Courts and agencies may also struggle with questions of venue, applicable law, evidence gathering, and remedies. If a system produces discriminatory outcomes in one country, but the company responsible for design and maintenance is located elsewhere, the affected individuals may face serious barriers in seeking accountability. This is one reason global AI enforcement cannot depend only on local complaint systems after harm occurs. It often requires proactive governance, cooperation, and shared expectations before deployment. International AI regulation, therefore, has to address the reality of differing legal and policy environments. Some governments may impose strict obligations on high-risk AI systems, while others may prefer lighter oversight to attract investment and technological development. These differences can encourage regulatory arbitrage, where companies choose to develop, test, or deploy systems in jurisdictions with weaker requirements. At the same time, overly fragmented regulation can create inefficiency and uncertainty, especially for smaller organizations that lack the resources to comply with many separate legal regimes. International organizations, standards bodies, and cross-border agreements can help reduce that fragmentation by creating shared principles, common terminology, technical standards, and cooperation mechanisms. Still, coordination does not mean that every country will regulate AI in exactly the same way, because legal systems reflect different political values, economic priorities, institutional histories, and public expectations. The broader lesson is that global deployment creates a serious oversight problem for governments seeking consistent control over AI technologies. A national regulator can pass strong rules, but those rules may be difficult to enforce when models, data, vendors, users, and harms are distributed across jurisdictions. That does not mean regulation is impossible. Enforcement has to be designed with cross-border realities in mind. Governments may need mutual assistance, shared audit practices, certification systems, reporting requirements, procurement rules, and penalties that apply to companies doing business within their markets, even if those companies are headquartered elsewhere. For AI professionals, the practical implication is clear. International deployment should never be treated as merely a technical scaling decision. Once an AI system crosses borders, it enters a layered legal environment where responsibility, compliance, documentation, and accountability must be planned with global governance in view. This final learning objective asks us to compare regulatory approaches used by governments and international organizations. That comparison matters because AI governance does not come from one source. National governments create laws, agencies issue guidance, courts interpret responsibilities, and international organizations shape shared expectations across borders. Each actor enters the conversation from a different position. A government may focus on protecting citizens, preserving competitiveness, and responding to public concern. An international organization may focus on coordination, common principles and standards that help countries work together when AI systems move across borders. Government regulation begins with the authority of the state to protect people from harm. This can include rules related to privacy, discrimination, safety, consumer protection, employment, healthcare, education, finance, and national security. In practice, governments can require organizations to document AI systems, assess risks, preserve records, allow audits, create appeal processes, or meet standards before deployment. They can also impose penalties when organizations violate legal obligations. That enforcement power matters because it can move responsible AI from a voluntary commitment to a legal requirement. At the same time, vague rules may fail to guide behavior, while rigid rules may struggle to keep up with technical change. A common theme in governmental approaches is the effort to balance protection and innovation. Policymakers understand that AI can support growth, discovery, public services, accessibility, cybersecurity, and better decision support. They also understand that uncontrolled deployment can produce privacy violations, biased outcomes, unsafe systems, opaque decision making, and loss of public trust. So the challenge is not simply to say yes or no to AI. It is to identify which uses require stronger oversight because they affect rights, safety, opportunity, or access to essential services. International organizations contribute differently because they often do not regulate through the same direct enforcement authority as a national government. Their influence comes through principles, recommendations, model frameworks, standards, research, convening power, and coordination among member states. They help create a shared policy language around accountability, transparency, safety, fairness, privacy, and responsible deployment. That shared language matters because global AI systems can create problems that no single country can fully solve alone. If every jurisdiction develops separate definitions and expectations, organizations face confusion, regulators face gaps, and affected people may receive uneven protection. When we compare these approaches, governments and international organizations are complementary rather than interchangeable. Governments provide legal authority, enforcement mechanisms, and jurisdiction-specific obligations. International organizations provide coordination, shared norms, and guidance that can influence national policy development. A government may adapt international principles into domestic law, and international organizations may learn from national experiments in regulation. This exchange matters because AI develops quickly and spreads through global markets, cloud platforms, supply chains, and digital services. The recurring values across these approaches are accountability, transparency, safety, fairness, privacy, and responsible deployment. Accountability asks who is answerable for an AI system's design, deployment, monitoring, and consequences. Transparency asks whether affected people, regulators, and stakeholders can obtain meaningful information about how the system is used and what its limits are. Safety asks you whether foreseeable harms have been evaluated and controlled. Fairness asks whether the system creates unjustified disadvantage or unequal treatment. Privacy asks whether data about people is handled in ways that respect legal and ethical boundaries. Responsible deployment asks whether the system should be used in a particular context at all, and under what safeguards. The larger takeaway is that AI regulation is becoming a layered governance environment rather than a single rulebook. Governments bring binding authority and must balance citizen protection with innovation and competitiveness. International organizations help shape the policy landscape for AI systems deployed globally. For professionals working in AI, this means responsible practice requires attention to more than one source of guidance. A system may be technically impressive and still fail if it ignores legal duties, policy expectations, international norms, or the rights of affected people. AI is now part of public life, and it must be governed through institutions capable of protecting people while still allowing beneficial innovation to develop.